Hello guys, welcome back. This time we're discussing criminal law. We're essentially first going to discuss the rationale behind the law of crimes. That is to say, the principles behind criminal law. Okay, before we go on to look at the specific provisions which are commonly asked in the CLAT exam. Okay, so first and foremost, let us discuss what is a crime. A crime is an unlawful act or omission which shocks the conscience of society and in respect of which legal punishment is inflicted on the person who is in default either by acting or by omitting to act. That is to say, everything that is declared to be a crime by law made by a competent authority is a crime. Okay, so a crime is basically due to an action or the omission of an action. Okay, and it is something that causes the conscience of society to be shocked. Okay, so as such, a crime is seen as greater than inflicting harm just upon one person. It is seen as a crime against society. It is seen as an action against society at large. Okay, as a result, you will find that in criminal cases, it is the state which prosecutes. It is not individual, it is not the victim of the crime who prosecutes, it is the state itself that prosecutes. Now, where can you find a list? Because everything that is declared to be a crime is basically a crime. Where do you find a list of criminal acts? Well, first and foremost, there's the IPC or the Indian Penal Code. This provides a list of all acts which can be called crimes. Okay, however, this list is not exhaustive and other statutes may also define and provide for the punishment of crimes. Okay, for instance, there's the NDPS Act, the Narcotic Drugs and Psychotropic Substances Act, which deals with the possession and the use of drugs. Okay, there's the Prevention of Terrorism Act, POTA. There's the Arms Act. There's also, say for instance, aside from these, which are acts which have been enacted by Parliament, there is also the SEBI insider trading regulations, which are basically put forth by SEBI, which is the Securities Exchange Board of India. Okay, these are regulations, but because SEBI is considered to be a competent authority, it can also frame acts which are crimes. Okay, thus the purpose of criminal law is to protect persons and property against intentional violence, unintended harm, and the protection of property against theft, fraud, or damages. Okay. So what are the objectives of criminal law? Criminal law is unique as it provides for serious potential consequences for failure to abide by its rules. It's not just that you have to pay a fine. It's not just that you have to do something in order to remedy some action or some failure to act that you have already done. It provides for serious consequences in the sense that you can go to jail. Okay, you can lose years of your life. So what are the objectives of criminal law? Now, 5 objectives that are widely accepted for the enforcement of criminal law by punishments are: first is the retribution principle. That is, criminals ought to suffer in some way because they have caused unfair detriment to others in some way. Okay, so because they have caused an unpleasant disadvantage to someone, the criminal should also be caused to suffer. Okay, this is seen as balancing the scales. Hence, it is called the retribution principle. Retribution means revenge. Okay. Next is the deterrence principle. Okay, the aim to impose a sufficient penalty on acts that are considered crimes is to deter or to prevent someone from actually taking that action because of the consequences. Okay, and this is not just aimed at specific offenders, but at society at large. Okay, then there's the incapacitation principle. That is to say, criminal law is designed to keep criminals away, physically away from society, so the public is protected from their misconduct. Thus, if somebody has committed a crime, they are removed from society, they are removed from any contact with society, from being able to affect society, and they're put in jail. They're put away from society. So they're incapacitated from affecting society in any way. So this is the incapacitation principle. Next is the rehabilitation principle, which aims at transforming the offender into a valuable contributing member of society and to prevent further commission of the offense by convincing the offender that their actions were wrong. Okay, that is by rehabilitating them into society. As regards rehabilitation, you must have heard in jails, they have education programs where prisoners can acquire education, they can do their degrees, okay, or they can acquire vocational training, that is, they can learn new skills, okay, which can help them become contributing members of society. So this is in pursuance of the rehabilitation principle. Okay, finally, there's the restoration principle, and the aim is to repair any injury inflicted upon the victim by the offender. Okay, this is the highest level of the objective of criminal law, if it is possible at all to repair the injury that is caused to the victim by the offender, then the courts or the state will act to provide such remedy. Okay, so these are the 5 major principles which are seen as the objectives behind criminal law. Okay, now what are the different types of crime? You can have crimes against the human body and life. You can have crimes against property. You can have crimes against public peace and order, such as treason and sedition, which are basically crimes against the state, where you're acting against the interests of the state. You can have crimes against religion. You can have crimes against family and the moral of family institution, such as bigamy, adultery, sodomy, etc. You can have economic crimes, such as stock market manipulation, piracy, hawala transaction, money laundering, etc. Okay, so in India, the Indian Penal Code deals with most of the criminal offenses. There are also specialized legislations that deal with and prescribe punishments for specific kinds of offenses. Okay. Now let's look at the basics of criminal law. Criminal liability is different from civil liability in the sense that a crime is considered to be related to moral turpitude and blameworthy and harmful for the whole society. Okay, so a criminal act is seen as being more grave, as being more serious than just causing someone some individual damage. It is seen as an action against society. Hence, it is the state that prosecutes crimes against offenders. Okay. Now, there are certain basic underlying conditions in the practice of criminal law. The first is presumption of innocence. That is, every accused is presumed innocent until proven guilty in a court of law. Okay, so even though you may be charged with a crime and you may be being tried for a crime, you are still to be presumed innocent unless you are proven guilty. Okay, then there's the right to defense. If you remember Article 21 of the Constitution, which states that every person accused of a crime has the right to be defended by a legal professional of his choice. That is, anyone who is accused of a crime has the right to mount a legal defense by a legal professional of their choice. Then there's the standard of proof. This is also something we've discussed. The onus of proving guilt of the accused is on the prosecution. Not only is the burden of proving guilt on them, but they need to prove that the accused is guilty beyond reasonable doubt. That is the standard of proof in case of criminal law. Okay? This is different from the standard required in a civil case, where the case is determined on the basis of the balance of probabilities. Okay? And finally, criminal liability. A legal obligation arising out of criminal offenses leads to criminal liability. A person who commits a crime incurs such criminal liability, and as a result of that, they will be imprisoned. Or they can be fined as well, but imprisonment is the usual course of action in the case of criminal liability. Okay? So, what acts constitute a crime? Okay? Now we know that it is only acts which have been listed under particular statutes by a competent authority are considered crimes. But what is the principle on the basis of which certain acts are considered crimes? First and foremost, the act has to be voluntary. Now, act here means a conscious or willful movement or action, and it can also involve conscious or willful omission to act, where a person is required to act. Okay, it is only voluntary acts that amount to offense, provided they have been defined as such. Okay, an act per se does not constitute a crime. In order to constitute criminal liability, it is not sufficient that there be mens rea, that is intent or the mental element, or that there is some action, but there must be mens rea as well as actus reus. Okay, that there should be a guilty intention as well as an action which takes forward that guilty intention in the commission of an act which is defined as a crime. Okay, the act should result in harm. Now, while this is the general rule, exceptions do exist. For instance, it is not necessary that the act should result in harm in case of offenses like treason, forgery, or criminal conspiracy. These are considered offenses per se. Okay, and finally, there's the rule of causation, which says that the causing of harm is a requisite of an offense, that the harm should have a causal effect with the act. That is, the harm should have directly resulted from the act. Thus, if the relation between the action and the harm caused is very remote, okay, the rule of causation will not allow for it to be considered a crime. It is only when the act directly causes the harm that it is considered a crime. Okay? Now, mens rea and actus reus are two crucial elements of a crime. Mens rea is the criminal intention, while actus reus is the criminal action. Okay? It is important that the criminal act must be accompanied by guilty intent. Without bad intention, there can be no crime, even if harm is caused by an action that fits the description of an offense or crime. Okay? Thus, a criminal act per se is termed as actus reus. Actus reus includes all the acts specified in the rule of law as constituting a forbidden act. It is basically the whole of the crime except for the mental element. Okay? So whatever is defined, whatever acts are defined as a crime, the acts themselves are basically what are called the actus reus. The mental element to give effect to those actions is called the mens rea. Okay? Both of these have to come together in order to constitute a crime. Okay? The term mens rea refers to volition, which is the motive force behind the criminal act or the conscious exercise of mental faculties to do an act. Okay? An act becomes a criminal act only when it is done with a guilty mind. However, cases of negligence stand as an exception. A negligent state of mind is to be considered a guilty state of mind as long as the negligence is deliberate or reckless or involves careless disregard for the life or property of others. For instance, if you are driving negligently on the road, that is to say, you are not intending to hurt or to kill someone, but you are negligent in how you are driving your car on the road, and as a result, you end up hurting or killing someone. In such a case, negligence will also be seen as requisite mens rea for the commission of the act of either hurt or murder, or culpable homicide not amounting to murder, however the charge is read. Okay? Thus, basically the takeaway from this is that there are two elements to a crime. One is the mental element, which is the mens rea, and the other is the actus reus, or the actual actions that constitute a crime. Now let's take a look at two crucial terms, knowledge and intent. Okay, these are two very related terms, okay, but in the constitution of mens rea, they are very important to draw a distinction between the two. Okay, while the mens rea element requires that there be intent to commit a crime, that is, the person committing the act should intend that a consequence follows from his actions, there is a question of whether the knowledge that certain consequences will follow is enough to constitute intent. Okay, for instance, if a person throws bricks into a crowd gathered at the street, resulting in a head injury to a member of the crowd that eventually leads to his death, can the offender be said to have the intent to commit murder? Or can he simply be said to have knowledge that his actions can lead to someone's death? Now, this is the fundamental difference between the crimes of murder and culpable homicide. Okay, knowledge versus intent. Now, generally speaking, intention and knowledge are used interchangeably. That is to say, if you have the knowledge that certain actions will lead to certain consequences, it is also to be assumed that you have the intention that your actions will lead to those consequences. Okay, and that intention can be presumed from the knowledge of the act, of the consequences from the given set of actions. Okay, however, there are certain crimes where knowledge and intent are read separately. For instance, murder and culpable homicide not amounting to murder. Okay. Also, there is the question of motive versus intent. Now, these are also two crucial principles involved in determining the mens rea element in the commission of a crime. In criminal law, there's a sharp distinction between intent and motive, but this distinction is often neglected. Okay. Motive is the moving power which impels one to action for a definite result, whereas intent is the purpose to use a particular means to effect such a result. Okay, that is to say, motive is not an element of a crime, while intent normally is. Okay, so motive is basically, say for instance, when you are asking the question, what is the motive that drives a person to do something? Okay, you're trying to reason from outside. What is the reason behind the actions committed by someone? Okay, what is the final aim they were looking to achieve? Whereas intent is more subjective. Okay, it looks specifically at whether that person intended that those end results should have been caused as a result of the actions that they took. So the question of motive suggests an inquiry into the state of mind of a person and his thoughts, while intent can be established based on a person's manifest external actions. Okay, by distinguishing between intent and motive, the chances of legislating thought crimes are avoided, since the commonly required element of a criminal intent will only be manifested once there are certain overt acts or omissions by an accused. Okay, so you must have heard of the expression thought crimes. For instance, in North Korea, even thinking about going against the state is considered a crime. Okay, now in India or in most free countries, thought crimes are not considered crimes. That is to say, if you just have the motive to do something, if you just have the thought of doing something, which is a criminal act, that is not enough. It is also necessary that you must actually act in order to give effect to those thoughts for a criminal act to be committed. Okay, so a thought crime is not a crime. Okay, now general defenses available. Now usually you'll be given these as principles in the CLAT exam. General defenses that are available in case of criminal offenses. Now while a person is generally responsible for his act accompanied by mens rea, there are certain exceptions. One is accident. Nothing is an offense which happens due to an accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner, by lawful means, and with proper caution and care. Okay, so if you are driving on the road, okay, properly, your car is properly maintained, you are following all the traffic regulations, and an accident occurs, something happens which is outside of your control, okay, you will not be held guilty of a crime. Okay, mistake of fact is another general defense that is available in case of criminal action, in case of a criminal offense. Okay, nothing is an offense which is done by a person who is, or by reason of mistake of fact and not by a mistake of law, in good faith believes himself to be bound or justified in doing such act. For example, if you see on the road one person being attacked by another person and you go to his defense, and as a result you cause hurt to the other person, okay, and you mistakenly believe that this person is being attacked whereas nothing of the sort was happening, okay, then that is a mistake of fact, okay, not a mistake of law. A mistake of law is basically where you assume that a certain act is not a crime whereas it actually is a crime. Okay, in case of a mistake of law, that will not apply as a defense. However, where it's a mistake of fact, it will apply as a defense to a criminal action, to a criminal proceedings. Okay, now act of a child. Okay, due to tender age, nothing is an offense which is done by a child below 7 years of age. Such a child is excused because he does not have sufficient maturity or understanding to judge the nature and consequences of his act and conduct. Between 7 and 12 years of age, culpability depends on whether the child understood the nature and consequences of his actions. Above 12 years of age, a child is presumed to understand the nature and consequences of his acts. Okay, so there is a gradation, but if a child is below 7 years of age, then it is presumed that the child does not have the knowledge to understand, does not have sufficient maturity to understand the consequences of his actions. Between 7 and 12 years of age, you will look at the attending circumstances to presume whether the child had the necessary knowledge to judge the nature and consequences of his actions. Above 12 years of age, the child is presumed to understand the nature and consequences of his acts. Now, insanity is also a probable defense, is one of the general defenses available in criminal proceedings. Okay, nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act. Okay, a person can be legally or medically insane, that is, the person generally does not have the rational capabilities of realizing the consequences of their actions, that is, they are of unsound mind. However, in law, there are also cases of temporary insanity. Okay, that is, if something happens which causes you great emotional distress, okay, that for a certain period of time immediately after that, you are unable to comprehend the consequences of your actions. It is also a defense, okay, temporary insanity is also a defense in case of criminal proceedings, okay. Now, intoxication is another general defense available in case of criminal proceedings. Nothing is an offense which is done by a person who at the time of doing it, by reason of intoxication, is incapable of knowing the nature of the act or the fact that what he is doing is wrong or contrary to the law. However, the thing that intoxicated him should have been administered to him without his knowledge and against his will. Okay? So this is a necessary element to the defense of intoxication, that whatever intoxicant was consumed by the person should have been administered to him without his knowledge or against his will. This is contained in section 85 of the IPC. Okay? Then there's the right of private defense. The right of private defense is based on the cardinal principle that it is the principal duty of a man to help himself. Self-preservation is the prime instinct of every human being. It's recognized to be a prime instinct of every human being. However, to get the benefit of private defense, acts done in private defense should be proportionate to the harm faced. Okay? For instance, if somebody comes, attacks you with a stick and you shoot them with a gun, then that is seen as excessive. Okay? That is not seen as proportionate. If somebody attacks you with a stick and you hit them back with a stick and the person dies, then you can use the right of private defense as a defense in that criminal action. Okay? Other defenses involved are necessity, acts done out of necessity, okay, or acts done in good faith. Okay? Now, stages of a crime. What are the different stages of a crime? The following steps are necessary stages in the commission of a crime. There should be intention, there should be preparation to commit a crime, there should be attempt, and finally, the attempt should be successful in the commission of a crime. Okay? The first two stages do not attract criminal liability. That is, mere intention and mere preparation are not adequate or not enough for you to be convicted of a criminal offense. Okay? There are also practical reasons for not punishing the preparation of a crime, because it is quite possible that a person who originally had the intention to commit an offense may, before actually committing it, give up because of fear or change of heart or any other reason. Secondly, it's also difficult to state with certainty that the preparation was done with the intention of committing the crime. The preparation could have been done with certain other intentions as well. Now, an attempt to commit a crime is essentially a positive step toward the commission of the contemplated offense after the preparations have been made. Once an attempt is made, the perpetrator does not remain in a position to change his mind and go back without committing the crime. Okay, so an attempt is basically where a positive action has been taken in the commission of a crime. Okay, it's not just preparation, it's certain acts beyond preparation which have been taken with the intention of giving effect to a crime. Okay. Now, an attempt is an act which would have led to the actual commission of the crime itself if not interrupted by some external force or reason beyond the control of the offender. Preparation, on the other hand, is a step before attempt. Okay, a crime is attempted after making all necessary preparation. Okay, now in attempt to cause a crime, a person is punished for doing something in furtherance of his evil intention and design for carrying out the contemplated crime. Now, an attempt may not succeed either by chance or due to faulty designs of the perpetrator, but not for the benefaction of the perpetrator. That is, not because the perpetrator held back. Okay? It is because something went wrong during the commission of a crime that an attempt did not succeed. Okay? His mind is guilty and he tried to commit a criminal action, and therefore an attempt should be punished. An attempt, if successful, leads to the actual commission of the crime. It is only because of some reason beyond the control of the offender that the offense could not be accomplished in case of a failed attempt. Hence, punishing an accused for the attempt to commit a crime is justified. Okay? Now, preparation versus attempt. There are a few tests to determine whether an act amounts to mere preparation or an attempt to commit a crime. There's the test of proximity, that is, the act or a series of acts in order to be designated as an attempt to commit an offense must be sufficiently proximate to to the accomplishment of that intended substantive offense. Basically, the proximity of the actions separates preparation from attempt. Okay? When the actions taken are actually proximate to the effect sought to be caused, okay, the effect being the criminal act, then those actions can be considered an attempt. If the actions are not proximate, then it is seen as merely preparation. Okay? Then there is locus ponentiae, that is, an act will amount to a mere preparation and not an attempt if the person of his own accord gives up the idea of committing a crime before the criminal act is carried out. Okay? So if the person of their own volition, by themselves, give up the idea of committing a crime even after preparation, then that will not be seen as an attempt. Then there is the equivocality test. An act done toward the commission of an offense would amount to an attempt to commit the offense if and only if it unequivocally indicates the intention of the doer to accomplish the criminal object. Okay? That is to say, if we can infer from the actions that the person's attempt, the person's intention was essentially to commit that crime and nothing else, then the test of equivocality says that that is an attempt to commit the crime and not just preparation. And finally, there's the test of impossibility. Mere impossibility to do an offense cannot be a defense. Okay? And the person's subjective belief that a particular crime is possible to be committed is sufficient to convict him. For instance, it may be impossible in the real world to actually assassinate the Prime Minister. But if a person believes that it is possible, makes all sufficient preparations necessary to do that crime, that is to try and assassinate the Prime Minister, and makes an attempt, takes certain further actions toward it, then his subjective belief that it is possible to assassinate the Prime Minister is enough, and mere impossibility that it is impossible to assassinate the Prime Minister just because of the fact that it is difficult, it is impossible, okay, that will not be enough. Okay, so impossibility is not a defense in case the person subjectively believes that their actions are enough to commit a particular crime. Okay, now let's look at abetment to a crime. What is abetment? A person who does not himself commit a crime may, however, command, urge, encourage, induce, request, or help a third person to bring about a crime, and hence thereby may be guilty of the offense of abetment. Okay? When considering the law relating to abetment, the requirement of mens rea, that is the mental element, is essential for liability to be imposed. Okay? Abetment can be classified into different types. First is principals in the first degree, those who actually commit the crime through their own hands or through an innocent agent. Principals in the second degree, those who are present actually or constructively at the commission of the crime and extend aid and assistance for the commission but do not actually commit the act on their own. They are also to be considered abettors to a crime. Okay? Accessories before the fact, that is persons who are not present at the scene of the occurrence but counsel, procure or command another to commit the crime. And accessories after the fact, that is, even though they know that a person has committed an offense, knowingly receive, relieve, comfort, harbor, or assist the criminal from escaping from the clutches of the law. Okay, so these are the different cases in which a person can be held to be abetting a crime. Okay, abetment can be committed in 4 ways. Abetment by instigation. To instigate means to provoke, incite, urge, or to bring about by persuasion to do something. Okay, instigation can be conduct as well. Instigation need not just be verbal, it may be conduct as well. There needs to be a close causal relation between the instigation and the act committed. For instance, if A tells B that C has been saying bad things about him and B goes and attacks C, then in that case, you need to prove that there is a causal connection between the instigation and the act committed. That is, if you can show that A was actually provoking, was inciting B, okay, to actually go ahead and hurt C, then you can say that there has been abetment by A. Okay? If the causal connection is too remote, then you cannot say that there is abetment by instigation. Okay? A person is said to instigate when he actively suggests, stimulates, supports, hints, and insinuates the commission of the act. Okay? Abetment by conspiracy. The distinction between an offense of abetment by conspiracy and the offense of criminal conspiracy is that in case of abetment, mere agreement is not enough. Okay? In case of the offense of criminal conspiracy, mere agreement is enough. Mere agreement to come together and carry out a certain offense is enough. Okay? However, in case of abetment, mere agreement is not enough. An act or illegal omission must take place in pursuance of the conspiracy and in order to accomplish the thing conspired for. Okay? The persons who are initially guilty of conspiracy to commit an offense become guilty of abetting the offense as soon as an act or illegal omission takes place in pursuance of the conspiracy. Okay? So for abetment to conspiracy, it is not enough that a conspiracy must come together, that people must come together and conspire. An act needs to positively happen in pursuance of that conspiracy for abetment to be a crime. Okay, for abetment by conspiracy to be a crime. Then there is abetment by intentional aiding. Okay, now this is what we normally understand by the term abetment. Okay, where somebody actually helps in the commission of a crime. And then there is abetment by illegal omission. Okay, which is when a person is legally bound to do a thing but deliberately refrains from doing that. Then the person will be liable for abetment by illegal omission. Okay. Now let's take a look at the sample question. Principle: an act done by a child between 7 and 12 years of age is not an offense if he or she is not mature enough to understand the nature and the consequences of the act. Facts: A child of 9 years finds a gold chain in the house of his uncle and gives it to his brother B, aged 5 years, asking him not to tell anyone. The uncle reported it to the police station and the police conducted a search. During the search, the gold chain falls from the pocket of B, and when the police asks B, he says that it was given to him by his brother A. So will A be held liable of the crime? Now in this case, A is 9 years old, so he falls between, so the principle will apply to him, okay, that is he falls between 7 and 12 years of age, okay. So the question is, from his actions, can we infer whether or not he is mature enough to understand the nature and consequences of his act? What he does is, he first takes the chain, gives it to B, and then asks B not to tell anyone. So as a result, it can be inferred that he knows that he has done something wrong. Okay? As a result, we can say that he is aware of the nature and consequences of his act. Okay? Thus, in this case, A will be held criminally liable for the act. Okay, for the offense of theft. Okay. Now another sample question. Principle: self-defense is considered as a universal exception for intentionally causing harm. Facts: robbers armed with knives and crowbars broke the access door of a house and entered it. The owner of the house took his gun and threatened to shoot them. The robbers ran out of the house and started pelting stones. The owner opened fire. Having heard the gunshot, the police rushed to the place and announced that the owner must stop firing. The owner suspected mischief, continued to fire, and a policeman was injured by a shot. The robbers meanwhile fled. The owner was sued for attacking the public servant on duty. So will the owner be held liable in this particular case? Now the principle we're given again is, self-defense is considered as a universal exception for intentionally causing harm. So the requirement is that the harm caused should have been intentional. Now in this case, now the facts are a bit complicated. Robbers entered the house armed with knives and crowbars. Okay, the owner of the house took his gun and threatened to shoot them. The robbers ran out and started pelting stones on the house. The owner opened fire on the robbers. Okay, now so far it may be said that the owner's reaction of shooting is proportionate to the pelting of stones. However, subsequently the police arrive, announce themselves and ask the owner to stop firing. Now, by this time, the owner suspects mischief and continues to fire, as a result of which a policeman was shot. Now, there is no intention on the part of the owner to cause harm to the policeman. Okay, his intention is to protect himself from the robbers. Okay, robbers who are armed. Okay, as a result, it can be said that there is no intention to cause harm, okay, to the policeman. As a result, this can be considered an exception under self-defense. Okay, thus the owner will not be held liable, okay, for harming the public servant on duty. Okay. Another sample question. Principle 1. Any person may use reasonable force in order to protect his person or property. Principle 2. However, the force employed must be proportionate to the apprehended danger. Facts. Ravi was walking on a lonely road. Maniam came with a knife and told Ravi, "Your life or your purse." Ravi pulled out his revolver. On seeing it, Manian ran. Ravi shot Manian in his legs. So will Ravi be held liable in this particular case for causing harm to Manian? Now in this case, Manian was armed with a knife and he came and threatened to harm Ravi, okay, saying "your life or your purse." So basically indicating that he was prepared to take Ravi's life. Ravi pulled out a revolver. On seeing it, Manian started to run. Okay. Ravi shot Manian in his legs. Okay. So thus, the first principle, any person may use reasonable force in order to protect his person or property. So this principle will be satisfied, okay, because his life and property was definitely under threat, okay. However, on seeing the gun, because Manian started to run, it can be said that that threat to Ravi's body or property was over by that time. Hence, Ravi shooting Manian in his legs is excessive and not proportionate to the apprehended danger, because there is no apprehended danger any longer. Okay. As a result, Ravi can be held liable for causing hurt to Manian in this particular case. Okay. One more sample question, one last sample question. Okay. Principle 1, preparation to commit an offense is not an offense. Principle 2, after one has finished preparation to commit an offense, any act done toward committing the offense with the intention to commit it is an attempt to commit the offense, which by itself is an offense. Okay, so this is basically the definitions of preparation and attempt. Okay, facts. A wants to kill B. He buys a gun and cartridges for committing the murder. He then sets out searching for B, and when he sees B, he loads his gun and takes aim at B and pulls the trigger. The gun did not fire. So will A be held liable for attempt? Okay, so in this case, he has definitely gone through the stages of preparation. That is, he bought a gun and cartridges and he set out to search for B. Okay, now he went even further than preparation, which is when he sees B, he loads his gun, takes aim and pulls the trigger. It's only the fact that the gun itself did not fire that prevented B from being killed. Okay, as a result, A will definitely be held liable for attempt to murder B. Okay, now we will go ahead and look at the elements of certain specific offenses which are commonly asked in the CLAT exam. Okay, now we'll look at certain specific provisions of the law of crimes of the IPC basically, which are commonly used to ask questions in CLAT exam. Okay, you can look at past year's questions and you'll see these provisions appearing all the time. And it's just helpful to be familiar with what the provisions of these particular sections are. Okay, the first offense we're dealing with is criminal conspiracy. Section 120A of the IPC deals with the crime of criminal conspiracy. The provision states that when two or more persons agree to do or cause to be done, 1, an illegal act, or 2, an act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy. There's a proviso to this section, provided that no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act beside the agreement is done by one or more parties to such agreement in pursuance thereof. So what are the elements of a criminal conspiracy? 1 is that there must be an agreement between two or more persons. The agreement should either be to do an illegal act, that is, mere agreement is sufficient for the commission of the offense, or it must be an agreement to do a legal act by illegal means, in which case some overt act must be committed by one or more of the parties to the agreement. Okay. Next is sedition. Okay, the provisions related to sedition are contained in section 124A of the IPC. Okay. Section 124A states that whoever by words, either spoken or written, or by signs, or by visible representation or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection toward the government established by the law in India shall be punished by so and so. Okay. Disaffection here includes all disloyalty and feelings of enmity which brings or attempts to bring hatred or contempt against the government. Okay, and the statements or signs must be directed against the government of India. Okay, against the government that has been voted into power. Okay, thus in this section, the acts, the actions that are covered are by words either spoken or written, or by signs, or by visible representation, or otherwise. So the intention behind the action is that there should be an attempt to bring into hatred or contempt, disaffection toward the government established by the law in India. Okay. Next, we'll look at culpable homicide. That's section 299 of the IPC, which defines the crime of culpable homicide not amounting to murder. The provision states that whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. Okay, so in this case there is first and foremost the act. Okay, whoever causes death by doing an act. Okay, that's the actus reus. Then there's the mens rea element, which is first the act should be done with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, or with knowledge that he is likely by such act. So in this case there's knowledge as well as the mens rea element, with knowledge that he is likely by such act to cause death. Okay. Next is murder. Now this goes one step beyond culpable homicide not amounting to murder. Okay. This is section 300 of the IPC. Section 300 states that culpable homicide is murder if the act by which death is caused is done with the intention of causing death. Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person. Thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Fourthly, if the person committing the act knows that it is imminently dangerous, that it must in all probability cause death or such bodily injury as is likely to cause death, and commit such an act without any excuse for incurring the risk of causing death or such injury as aforesaid. Okay, so this section goes one step ahead of what the provisions of section 299 were. Okay, culpable homicide not amounting to murder looks at acts done with the intention of causing death or with no such intention of causing bodily injury as is likely to cause death, or with such knowledge that he is likely by such act to cause death. Okay, culpable homicide amounting to murder, that's murder, section 300 goes beyond that. So basically section 300 provides that culpable homicide is murder if the act by which death is caused is done with the intention of causing death. So the act should be directly causally related to the death, and there should be intention of causing death, like the act should be done with the intention of causing death. Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely. So there is the intention element as well as the knowledge element, knows to be likely to cause the death of the person to whom the harm is caused. Thirdly, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Okay, so in this case it's not necessary that there should be specific knowledge, okay, but the injury caused is such that in the ordinary course of nature it causes death. Even in such case it will be murder. Okay, and fourthly, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commit such act without excuse for incurring the risk of causing death or such injury. Okay, so there is no excuse that holds back the person from committing such an act. Okay. Section 300 also provides the following exceptions to the charge of murder. First, when the offender acted under grave and sudden provocation, which provocation was not caused due to his conduct. Okay. So if someone suddenly comes up on the road and points a gun at you and you pull out your own gun and shoot the person, then that first grave and sudden provocation of pulling a gun out at you and threatening you can serve as an excuse, as an exception to the charge of murder. Okay. Secondly, when death is caused by the exercise of right of private defense, which includes the right to defend others, like stopping rape. Okay. Thirdly, deaths caused by war or public duty which necessitated such deaths. So again, this is an exception to the charge of murder. Okay. Fourthly, when death is caused without premeditation in a sudden fight in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner. Okay, so if there is a sudden fight that happens and in the heat of the moment, okay, without the offender, that is the person who's accused, without him taking undue advantage or acting in a cruel or unusual manner, if death is caused, then that also acts as an exception to the charge of murder. And fifthly, when a person above the age of 18 years of age and of sound mind suffers such risk on his own consent, for example, in the case of risky sports, okay, in that case, a charge of murder will not apply. Now, culpable homicide versus murder, let's just quickly take a look at the difference between the two. There's a thin difference between murder and culpable homicide. It has been repeatedly held by the courts that culpable homicide is the genus, that is the broader category, and murder is the species, the more specific category. Okay, that is, all murders are culpable homicides, but all culpable homicides are not murders. Okay, there are express exceptions provided in the case of murder, which are not provided in the case of culpable homicide. Okay, so an act, even if it falls under the exceptions to the case of murder, may still fall under the case of culpable homicide. Okay, and the difference between murder and culpable homicide is essentially one of degree. This is something that has been held consistently by several cases, by various courts. Okay, murder is the deliberate, often planned and carefully executed unlawful killing of another individual, while a culpable homicide may not be. Okay. Now, section 304B, dowry death. This is another provision from which CLAT questions are often asked. Okay, not very often, but still you will find this every now and again. The provision defines dowry death as where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry. Such death shall be called a dowry death, and such husband or relative shall be deemed to have caused her death. Okay. Now this provision more or less is self-explanatory. Okay, it provides for dowry deaths. Okay. Now let's look at wrongful restraint. The crime of wrongful restraint is defined in the section 339 of the IPC. The provisions state that whoever voluntarily obstructs any person so as to prevent that person from proceeding in any direction in which that person has a right to proceed is said wrongfully to restrain that person. Exception: the obstruction of a way over land or water which a person in good faith believes himself to have a lawful right to obstruct is not an offense within the meaning of this section. So basically, if you prevent a person from going in any direction that the person has a lawful right to proceed in, okay, then that constitutes the wrong or the crime of wrongful restraint. Okay, the exception being that if the person causing such an obstruction believes in good faith that he has the lawful right to cause such an obstruction, then that is not an offense within the meaning of section 339. Okay. Wrongful confinement is another provision. Okay, wrongful confinement, basically section 340 states that whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is said to wrongfully confine that person. So wrongful restraint means that you physically bar that person from going in a certain direction. Wrongful confinement, on the other hand, deals not only with physically confining with someone, but also in other ways restraining a person from proceeding beyond certain circumscribing limits. Okay, and that is said to be a wrongful confinement. Okay, that is said to, in that situation, it is said that the person is being wrongfully confined. Okay. Okay, the next provision we're going to discuss is section 361 of the IPC, which defines the crime of kidnapping from lawful guardianship. The provisions of section 361 are as follows. Whoever takes or entices any minor under 16 years of age if a male, or under 18 years of age if a female, or any person of unsound mind out of the keeping of the lawful guardian of such minor or person of unsound mind without the consent of such guardian is said to kidnap such minor or person from lawful guardianship. So basically, for persons who are minors, that is under 16 years of age if a male, or under 18 years of age if a female, or any person of unsound mind, okay, they are said to have a legal guardian, okay, a lawful guardian. So if such a minor or such a person of unsound mind is taken out of the care of the lawful guardian without the consent of such guardian, then it is said to be the crime of kidnapping. There is an exception to this section, however. This section does not extend to the act of any person who in good faith believes himself to be the father of an illegitimate child, or who in good faith believes himself to be entitled to the lawful custody of such child, unless such act is committed for an immoral or unlawful purpose. Okay, so the only exceptions that are provided to the crime of kidnapping are if the act is done by someone in good faith who believes himself to be the father of an illegitimate child and thus takes such illegitimate child into custody, or who in good faith believes himself to be entitled to the lawful custody of such child. So it can be certain relative or somebody who believes that they are entitled to the lawful custody of such a child, unless such an act is committed for an immoral or unlawful purpose. This will not constitute kidnapping. Okay. Now, similar to kidnapping is the crime of abduction, which is defined in section 362. The provisions of section 362 are as follows. Whoever by force compels or by any deceitful means induces any person to go from any place is said to abduct that person. So the ingredients of the offense of abduction include the following: forcible compulsion, which may include use of actual force, okay, inducement by deceitful means, that is misleading a person by making false representations, and a person in this case could include a minor as well, but it generally includes everybody. Okay, it could be a grown-up and adult person, it could be a minor, it could be a person of unsound mind, it could be any of these. Okay, so abduction as such is wider than the crime of kidnapping. Okay, kidnapping specifically deals with minors or persons of unsound mind. Okay, whereas the subject of the crime of abduction could be any person. Okay, now we'll come to another provision, which is mischief. Provisions relating to the crime of mischief are contained in section 425 of the IPC. Section 425 states that whoever with intent to cause or knowing that he is likely to cause wrongful loss or damage to the public or to any person causes the destruction of any property or any such change in any property or in the situation thereof, and destroys or diminishes its value or utility or affects it injuriously, commits mischief. So mischief is basically a crime against property. Okay, so whoever with intent to cause or knowing that so there's both the element of intent as well as knowledge involved. Okay, so whoever does the action with the intent or knowing that he's likely to cause wrongful loss or damage to the public or to any person, and thus causes the destruction of any property or any such change in property or in the situation thereof, that is the location of the property, okay, as destroys or diminishes its value or utility or affects it injuriously, is said to commit mischief. Explanation to this section is, it is not essential to the offense of mischief that the offender should intend to cause loss or damage to the owner of the property injured or destroyed. Okay, so in this case, it is sufficient that he intends to cause or knows that he is likely to cause wrongful loss to any person by injuring that property, okay, whether it belongs to that specific person or not. Okay, so the crime of mischief is basically a crime against property, regardless of who the owner is. Okay, so it is not necessary that the person causing mischief should intend to cause loss or damage to the specific owner of that property. Okay, it is just enough that that person should cause damage or cause diminishing of value or utility of that particular property. Okay, now next we will come to another section, a provision on defamation, criminal defamation. Now the defamation has two aspects to it. One is the civil aspect, okay, where you can file a suit for civil defamation in which case you are basically seeking to file a suit for damages, okay, for harm, for monetary harm that may have been caused due to defamation. Okay, then the other aspect of defamation is criminal defamation, which is contained in section 499 of the IPC, okay, whereby basically you are looking to imprison a person because they have caused defamation to you. Okay, so section 499 of the IPC defines defamation as whoever by words either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person, is said, except in cases hereafter accepted, to defame that person. Okay, so basically this is a crime against the reputation of a person, not against the body of a person or not against property. The defamation is a crime against the reputation of a person. So whoever, and it's pretty wide in how it's framed, whoever by words either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning the person. Okay, so basically either by spoken words or by written words or by signs or visible representations, okay, these are the acts that may constitute the crime of defamation. Okay, and the intention is intending to harm or knowing or having reason to believe that such imputation made may harm the reputation of such person. Okay, except in the provisions provided hereafter, it is said to cause defamation to that person. Okay, explanation 1 to this section says it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living, and is intended to be hurtful to the feelings of his family or other near relatives. Now, as such, a dead person cannot be defamed. Okay, but this explanation provides for an exception to that, which is that if anything is said, anything of the sort, anything written or anything intended to be, if anything written or anything spoken or anything by any signs or visible representations are made, basically which impute to a deceased person such things that if the imputation would harm the reputation of that person if living, okay, and is intended to be hurtful to the feelings of his family or other near relatives, then that may amount to defamation. Okay, explanation 2 says it may amount to defamation to make an imputation concerning a company or an association or collection of persons as such. So a company or a partnership or a collection of persons, an association, a cooperative, may also file a suit for criminal defamation. Okay. Explanation 3 says that an imputation in the form of an alternative or expressed ironically may amount to defamation. So also where you're using sarcasm, okay, that also may amount to defamation. Okay, where you're meaning something ironically or you're meaning something sarcastically, okay, not saying something directly, that also may amount to defamation. Finally, explanation 4, no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others lowers the moral or intellectual character of that person, or lowers the character of that person in respect of his caste or calling, or lowers the credit of that person, or causes it to be believed that the body of that person is in a loathsome state or in a state generally considered as disgraceful. Okay, so now this provides a limitation to what may constitute harm to a person's reputation. Okay, so this is basically an elaboration of the provisions contained in section 499. Okay, explanation 4 says that no imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimation of others. So this is important. How do you estimate, how do you tell that a person's reputation has been lowered or that a person's reputation has been harmed? Okay, so it is in the estimation of others, okay, and in the estimation of what are called right thinking members of society, that is normal people, okay, not people who are especially sensitive or people who are placed in a special position, okay, but in the estimation of normal right thinking members of society, if something is said or done which lowers the moral or intellectual character of a person, or lowers the character of that person in respect of his caste or of his calling, or lowers the credit of that person, or causes it to be believed that the body of that person is in a loathsome state or in a state generally considered as disgraceful, then it may constitute the crime of defamation. Otherwise, it may not constitute the crime of defamation. So, okay. So these were some of the provisions which are commonly used to ask questions in the CLAT exam. Okay. Next, in the next session, we'll basically take a closer look at intent and criminal defamation, because these very commonly are used to ask questions in the CLAT exam. Okay. And we'll briefly look at these two aspects of criminal defamation and basically of intent. Okay. We'll look at a few examples to further elaborate on what these mean. Okay, so join us for that session. In the meanwhile, keep practicing, and good luck, and see you next time. Okay, bye.